Welcome, everybody. I'm Robert Willner. I'm a partner with Buckhalter in the Commercial Finance Group. And we are here today for a webinar on taking a pledge of the equity interests of loan parties. This webinar is going to be primarily focused from the perspective of secured lenders, although other parties may also find this to be of interest. Also, the program does qualify for California MCLE credit. So if there are attorneys who are participating, I will, at the end of this program, I will provide you with a code and an email address where you can send the code to confirm your attendance, and then we will be providing you with 1 hour of CLE credit for today's program. So also we have a chat feature. So if there are questions as I go along, please go ahead and put them in the chat. And then at the end of the program, I'll take a look at the chat and see the questions, and I'll do my best to answer as many questions as we have time for. If we run out of time, then feel free to email me or call me at Buckhalter, and be happy to answer any questions that we didn't have time to address during the program. So with that, let's begin. We'll start. So first is, what is equity? Equity, we can define as the value that would be returned to the company's shareholders if all of the assets were liquidated and all of the company's debts and liabilities were paid off. That's what we're talking about taking a pledge of. Sorry. So now this usually, but not necessarily, includes the right to vote on certain matters. So that would include the election of directors, a sale or merger. So if you have a pledge and you foreclose on the pledge, you would be entitled to vote on those matters. What's evidence of equity? Equity can be evidenced by either a stock or a membership interest certificate, stock ledger. If it's an LLC, then there typically would be a schedule of members that's attached to the LLC operating agreement. So what is this worth? What's the value of this? Why would you want to take this as collateral to secure a loan obligation? If we get a pledge of 100% of the equity of a company, that captures the going concern value, which may be greater than the value of the assets. But note that if we sell by means of a stock sale as opposed to an asset sale, that's going to carry with it the liabilities of the company. That's the downside. Another question I'm often asked is, got a borrower that has multiple shareholders, and one is a minority shareholder, and he's hard to reach. Do we really need to get a pledge of 100% of the equity? The problem with getting a pledge of less than 100% of the equity is that limits the pool of potential buyers. Let's say, for example, that we get a pledge of 90%. Think about who would be the possible buyers of 90% of the equity of a company when the remaining 10% shareholder is hostile. The likelihood is that there's the only likely buyers of something like that would be that minority owner. and that owner may or may not have the ability to buy. So sometimes when we have multiple owners of a company, a holding company structure is the best way to simplify the transaction. When you have a holding company, all we need is one pledge from the holding company, as opposed to a separate pledge from each owner. Let's take a look. Another advantage, I'll come back to the other advantage. Okay, so in this figure, let's say we have a borrower that has 4 owners. So instead of getting up 4 different pledges, we have a holding company where we just have one pledge from the holding company. And the equity owners are now, instead of having equity directly in the borrower, they have indirect equity in the borrower through the holding company. Their beneficial interest is identical either way. But the difference is that in this case, we only need one pledge agreement, and these 4 owners don't need to sign anything. So that's another advantage of the holding company, is that we don't have to chase the individual equity owners to have them sign our pledge agreement. So how do we go about getting a pledge? Technically, a pledge is a possessory security interest. But informally, people talk about a pledge to include any type of security interest. But the classic example of a pledge is a pawn shop, where the pawn shop takes physical possession of the debtor's property to secure the pawn shop loan. In order to know how we take a pledge, we have to understand first that the UCC divides types of collaterals into different categories. Most of you are familiar with this. And so a pledge of the security interest in the equity will be created by a security or pledge agreement signed by the debtor, in other words, the owner of the equity, that grants a security interest in the equity described in one of 2 ways. Either by the UCC category or by a specific description. So the first step in obtaining a pledge is determining which UCC category it belongs in. Categories, as most of you know, would include accounts, documents, equipment, inventory, general intangibles, investment property, and so forth. So we need to determine which one of these categories does the equity belong in. So you might think maybe it's investment property, which is defined under the UCC as including a security. Maybe you might think it's a general intangible, which is a none of the above category. If it's nothing else, then it's a general intangible. Security is defined in, not in Article 9 of the UCC, but it's defined in Article 8. Section 8102 says that except as otherwise provided in Section 8103, an obligation of an issuer or a share, participation, or other interest in an issuer or property or an enterprise of an issuer, that is all of the following. Number 1, represented by a security certificate in either bearer or registered form, or the transfer of it may be registered upon the books maintained for that purpose by or on behalf of the issuer. 2, remember it has to be all of the following. It's one of a class of security of a series, by its terms is divisible into a class or series of shares, participation, interests, or obligations. And 3, it is either of the following. It's either the type dealt in or traded on a securities exchange, or it is a medium for investment and by its terms expressly provides that it is a security governed by Article 8 of the UCC. So just because a company is not a public company, a private company can be a security too, if it is a medium for investment and its terms expressly provide that it's a security governed by Article 8. And then, no surprise, a security certificate is defined as a certificate representing a security. And likewise, an uncertificated security means a security that is not represented by a certificate. So, but the UCC makes it easy. So rather than go through all of this analysis for trying to figure out if the equity is a security, Section 8103A makes it very simple. It says a share or similar equity interest issued by a corporation, business trust, joint stock company, or similar entity is a security, period. On the other hand, an interest in a partnership or a limited liability company is not a security unless it is dealt in or traded on securities exchanges or in securities markets, or its terms expressly provide that it is a security governed by Article 8 of the UCC. This language that I've underscored here is referred to as opting into Article 8. So, an interest in a corporation, I'm summarizing, an interest in a corporation is a security. An interest in a partnership or a limited liability company is not a security unless it's opted into Article 8. So we know that equity in a corporation is investment property because a security is investment property. And we know that equity in a partnership or a limited liability company is not investment property unless the issuer has opted into Article 8. So then you would ask, if the equity is not investment property, what is it? Well, it falls into the none of the above category. It's a general intangible. So how do we perfect our security interest in the equity? The method of perfection depends on the category of collateral. Remember, we know that it's either going to be a security or it's either investment property or it's going to be a general intangible. If it's a general intangible, and remember, it can only be a general intangible if the issuer is a limited liability company or a limited partnership. So if we're talking about taking a pledge of the equity of an LLC or a limited partnership, the way to perfect our security interest is by filing a financing statement, naming the debtor and secured party, and describing the collateral either specifically or as general intangibles. Most cases where we're providing working capital financing to a company, we'll be filing an all assets UCC 1, but an all assets UCC 1 includes general intangibles. You have to make sure that the security agreement still describes either general intangibles or specific reference to the to the type of equity. But in the UCC1, we can do an all assets filing, and that would get you the perfected pledge in the general intentions, in the equity. On the other hand, if we're talking about investment property, in other words, we're getting a pledge of the equity of a corporation, we have choices. We can either perfect by control or filing a financing statement. Same as the above, but describing the collateral either specifically or as investment property. And again, a blanket or all assets UCC1 includes investment property. If the shares of the equity of the corporation are certificated, we have control by taking possession of the original certificate, not a copy, has to be the original certificate, and an endorsement, in other words, a stock power, signed by the owner of the certificate. If the shares are not certificated, then we get control by either a control agreement, which is similar to a DACA, except instead of, with a DACA, it would be signed, DACA would be a tri-party agreement signed by the depository bank, the secured party, and the debtor. In the case of a control agreement covering the investment property, it would be a tri-party agreement that would be either signed by the issuer, if it's privately held, or the broker, if it's publicly traded. What if there are two secured parties who both have a claim to the same equity? If we've perfected our security interest by filing a financing statement, then it's going to be the usual first to file rule. So whoever has filed first will have the senior lien, and whoever is filed afterwards would have a junior lien. But note that if there are two secured parties who both have a lien on the same equity, and one of the secured parties has control and the other one does not have control, in other words, it has perfected its security interest by taking possession of the stock certificate or a DACA, and the other one has perfected by filing, guess who wins? The secured party who has control has the senior lien, even if that secured party obtained control after the financing statement of the other secured party. This is the big advantage of control, is that it gives you priority, even if you are not first in time. And that is the reason why in a limited liability, if you're taking a pledge of a limited liability company, you want the equity to be classified as investment property, not a general intangible. That allows you to perfect by taking control. So in sum, perfection of a pledge of investment property may be by possession or filing. A secured party having a possessory security interest in the investment property will have priority over a competing secured property having a non-possessory security interest regardless of timing. Pardon me, my cursor is moving faster than me. I want to amend this second bullet point. Instead of saying possessory security interest, I want to say control, because control can either be by possession or through a control agreement, depending upon whether the security is certificated or not. If the equity is a general intangible, in other words, it's a limited liability company or a limited partnership that has not opted into Article 8, then your only choice for perfection is by filing a financing statement, and then priority is going to be based on the first to file rule. So let's talk about a pledge agreement. What do you want the pledge agreement to contain? Well, you want it to have a granting clause, granting a security interest in the equity. It should discuss who has rights to distributions before and after an event of default. Typically, we permit the owner of the equity to receive distributions prior to an event of default, subject to any restrictions that there might be in the credit agreement regarding distributions. But after an event of default, we want it to be clear that all distributions go to the secured party. Voting rights should be included in a well-drafted pledge agreement. And again, typically before an event of default, we typically would allow the voting rights to remain with the owner. But after an event of default, we would want the voting rights to go to the secured party, even prior to foreclosure. A well-drafted pledge agreement should include any after acquired equity, stock splits, options, so forth, as part of the collateral. There should be anti-dilution provisions. So if you're expecting to get a 100% pledge, you wouldn't want the issuer to issue additional equity to a third party and thereby dilute your pledge. So there should be anti-dilution provisions that prevent that from happening. There should be a power of attorney and a proxy to transfer ownership after foreclosure. And if it's a third-party pledge, we want to make sure that we include suretyship defense waivers, because a third-party pledge will be deemed to be tantamount to a guarantee, a limited recourse guarantee. Lastly, let's just talk briefly about some bankruptcy considerations. So if the company that you have a pledge of files for bankruptcy, we all know that an automatic stay will go into effect that will prevent the creditors of the company from exercising remedies against the company. But note that the bankruptcy of the company does not impact the creditors of the pledgeor. So as long as the pledgeor is not in bankruptcy, the bankruptcy of the company does not prohibit the secured party from foreclosing on the stock of the equity. And here is the key advantage to having a pledge of the equity. So as long as if the company's in bankruptcy, but the pledgeor is not, then the secured party can foreclose on the equity and vote the equity's claim in bankruptcy. So let's talk about why is that an advantage. Let's say that in a bankruptcy, we, the secured party, are in favor of a reorganization or a 363 sale, and the owner of the equity is not in favor of that and would vote against that in the bankruptcy proceeding. If we have foreclosed on the equity, we can vote the equity's claim to favor whatever it is that we want to happen. Now, there may be other reasons why that might not, why the sale might not go through or the reorganization might not go through, because there are other parties, other claimants in the proceeding that also have a vote. But at least we can make sure that the equity claim is aligned with the secured parties claim. And then the flip side of that is that if the pledgeor is in bankruptcy, then we wouldn't be able to foreclose. We would have to deal with the facts that are on the ground at the time. That's the end of the program. So let me see if we have any questions. Here we go. Oh, hi, Leslie. Let's see, if the creditor holds a security interest in the assets and a lien on the equity owned by a holding company, could there be an issue of equitable subordination? That's one. So now you're getting above my pay grade. So I'm going to refer that to one of my bankruptcy partners, and I'll get back to you after the program, and I'll shoot you an email. Yes, the PowerPoint is available. Martha, can you shoot a copy of the PowerPoint to all of the participants? We'll get a copy of the PowerPoint to.
Yes, I'll do that.
Okay, great. Thanks, Martha. And my contact information is on the last page of the PowerPoint. So if anybody has a follow-up question, they can just shoot me an email and I'll be happy to respond. Thank you very much. Let's see, any more questions? Keith Nichols, hey Keith, why wouldn't the equity holders set up a holdco? It would push into bankruptcy at the same time. It might, it likely would happen. Typically equity sponsored deals, that's exactly what would happen. So then we wouldn't be able to foreclose on the equity, or we would need to get relief from the automatic stay. And we might be able to get that if, you know, the holdco has no other creditors and the only asset is the stock of the opco, then we might be able to get relief from the automatic stay. But yes, that's how that would likely play out. Right. Leslie Reuter of Union Bank says, in the Liberty House bankruptcy, the bank group exercised its voting rights and voted a new board. Exactly. There were then two competing boards. Well, yeah, I don't know why there would be competing boards, because the new board, if they were duly elected, that should have superseded the old board. But Leslie, we'll get I will get up one of my bankruptcy partners, and the two of us will give you a call and go through your questions. Any more questions? Okay, so the code for CLE credit is pledge, PLEDGE, and you want to email to Aaron Hart, that's EHART @buckhalter.com. Again, EHART @buckhalter.com with the code word pledge. And Aaron will return a CLE certificate, a California CLE certificate, to any of the attorneys who request it, any attorneys listening who request it. That's it for today's program. Thank you, everybody, for participating. I hope that you found this useful. And one more question. Does the type of partnership matter in determining whether the equity is investment property? What do you mean by type of partnership? As opposed from limited or general partnership? The UCC only talks in terms of limited partnerships. Does that answer your question? So if it's a limited partnership or an LLC, then the equity is going to be classified as investment property unless the issuer has opted into Article 8, in which case it would be a security. If it's a general partnership is not a legal person. It's going to be, if a general partnership, you're going to have to, there would be nothing to pledge. All of the owners of a general partnership have equal and undivided interest in the property owned by the partnership. So I don't think you can pledge a general partnership interest. But having said that, I'm gonna check with one of my corporate partners about that and get back to you about that too. You're welcome. Okay, so Leslie, I'll get back to you later this afternoon or tomorrow, whenever I can get one of my partners available to call you. And to everybody, thank you again for attending. I hope you found the program useful. And if you have follow-up questions, you can contact me. My contact information is at the end of the PowerPoint presentation.